candidature of the petitioner for the post of constable has been rejected on the ground that one criminal case was registered against him and the said fact has been suppressed by the petitioner in his character verification form. Justice G.S. Ahluwalia of Madhya Pradesh High Court observed that the petitioner was prosecuted and he was acquitted because of the fact that all the witnesses had turned hostile. Although the complainant had stated in favor of the prosecution in the examination in chief, but he wrestled from his statement in his cross-examination. Further, the petitioner had suppressed the material information in his character verification form. Under these circumstances, that no illegality has been committed by the MP police in rejecting the candidature of the petitioner for the post of Constable General duty. The petition fails and is hereby dismissed. Neeraj Kumar vs. State of MP, July 7, 2021.
Doctrine of lis pendens is derived from the Latin maxim, ut pendent nihil inevita, which postulates that, during litigation nothing should be changed. Partition. Whatever be the nature of the allegations, the parties may have against each other, as long as the partition suit is pending, the principle of lis pendens applies in its full force, and therefore, any transactions done or entered into by the parties, in the midst of such proceedings, would have no effect on the other.
Though the appellant herein, the wife of the deceased, has been examined, and a contention has been put forth with regard to her statement, it is not the evidence in its entirety and it is premature to conclude on the basis of a stray sentence. Merely classifying the appellant as the principal star witness, and referring to her statement is of no consequence, since the entire evidence will have to be assessed by the Sessions Court, before arriving at a conclusion. Mere examination of the appellant cannot be considered as a change in circumstance for the High Court to consider the fourth bail application of the respondent number 2 and enlarge him on bail. Supreme Court in Mamta Nair vs. State of Rajasthan, July 12, 2021.
A person already under arrest can still be detained under the National Security Act 1980, if three conditions are satisfied. 1. Detaining authority had knowledge about detainee's custody. 2. There exists real possibility of detainee's release on bail, and 3. Necessity of preventing him from indulging in activities prejudicial to the security of state or maintenance of public order upon his release on bail. Observed by a division bench of Madhya Pradesh High Court in Sonu Barwa vs. State of MP, July 7, 2021. A person already under arrest can still be detained under the National Security Act 1980, if three conditions are satisfied. 1. Detaining authority had knowledge about detainee's custody. 2. There exists real possibility of detainee's release on bail. 3. Necessity of preventing him from indulging in activities prejudicial to the security of state or maintenance of public order upon his release on bail. Observed by a division bench of Madhya Pradesh High Court in Sonu Barwa vs. State of MP, July 7, 2021.
Precedent. A judgment of a court cannot be read as Euclid's theorem. Little difference in facts or an additional fact may make a lot of difference in the precedential value of a decision.
Public order. It is very wide, and during pandemic-like situation, action of blacklisting of essential drug like remdesivir brings the action within the purview of public order.
The explanation does not eclipse the entire main provision, namely Section 3 Clause 2 of National Security Act 1980. Indeed, it only takes out the aspect of blacklisting of certain commodities, which are covered by the Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act, 1980.
The object of an explanation to a statutory provision is ordinarily a. To explain the meaning and intent of the act itself. b. Where there is any obscurity or vagueness in the main enactment, to clarify the same, so as to make it consistent with the dominant object which it seems to subserve. c. To provide an additional support to the dominant object of the act, in order to make it meaningful and purposeful. d. An explanation cannot in any way interfere with or change the enactment, or any part thereof, but where gap is left which is relevant for the purpose of the explanation, in order to suppress the mischief and advance the object of the act, it can help or assist the court in interpreting the true purport and intendment of the enactment. a. It cannot, however, take away a statutory right with which any person, under a statute has been clothed, or set at naught the working of an act by becoming an hindrance in the interpretation of the same.